Hey everybody, it's Mauricio Rauld here, founder and CEO of Premier Law Group, your premier syndication attorneys. And today, we're going to talk about the charging order. Probably one of the most important concepts that one needs to understand when we're talking about domestic asset protection structures. And as a real estate syndicator, it's critical that we understand these concepts. So today I wanted to dedicate a whole video just to the charging order protection. Now, I think the best way I can explain this is to actually show you why the charging order even exists and the policies behind it. And I think once you understand that concept, then the concept of charging order is going to make a lot more sense. And so I drew up this really simple schematic. This is obviously not a real estate syndication schematic. I did a video on that previously, which we can probably put up somewhere. But let's just say you have a piece of property or a business or some kind of a valuable asset that you own in an LLC, a limited liability company. This LLC is owned by two individuals, and these are business partners, Sally and John. They're not married, that's an important distinction. They're simply business partners, where John owns 60% of the LLC, Sally owns 40% of the LLC. Okay, so we have a multi-member LLC that owns either a piece of property or a business. Now, let's assume John gets into some trouble. Gets into a business dispute, gets into a car accident, maybe has a default on a loan. Something happens to John that has absolutely nothing to do with the property, nothing to do with this business, nothing to do with Sally. But there's a judgment now from this creditor of $1 million against John personally, right? So now there's a judgment personally. What are the options? If you think about it, if we were simply to give John's 60% ownership, that's his asset. If he was forced to turn over that asset over to the creditor in order to satisfy all or part of that judgment, then what ends up happening is the creditor now owns 60% of the entity and Sally owns 40% of the entity. And now Sally is forced to be in business with somebody she doesn't know, and quite frankly, the creditor has really no interest in running this business or running this piece of property. They just want to liquidate and get paid. So it creates this tension between the creditor and Sally. And so from a public policy standpoint, it doesn't make any sense to simply hand over John's interest in the LLC to the creditor and have the creditor come in, own the LLC, control the LLC along with Sally, because they're just not on the same page. And so what the laws have come up with in every single state, all 50 states have this, is actually doing a charging order protection, which is instead of giving the creditor ownership in the 60% of the LLC, what the creditor ends up getting is just the financial rights, right? So whatever distributions would have gone to John, we're going to divert those and go pay the creditor until that $1 million judgment has been satisfied. That way, John and Sally can continue to run their business. They can do whatever they want with the property because the creditor won't have any ownership in the LLC and they won't have any control of the LLC. So this is strictly a public policy issue with the charging order. Now, the important part here is we want to make sure, because this is something that really John wants to have, right? Because they want to have this setup where they don't have to give over their 60% over to the creditor. So we want to make sure that this LLC is created in a state where the charging order protection is the exclusive remedy. That's the word we're looking for in the statute. Is the charging order the exclusive remedy by which this creditor can get the financial rights to this LLC? Because some states that are very poor asset protection states just list the charging order as one of the many options. So a charging order may be given, that's another key term, may be given to the creditor, but the creditor may have other options. The judge has other options to provide the creditor, so maybe they do end up giving 60% to the creditor. Maybe the creditor is entitled to foreclose on the LLC and ultimately get control. And so when we're talking about asset protection and specifically charging order protection, you want to make sure these LLCs are created in states where the charging order is the exclusive remedy available to the creditor. That way, John doesn't lose control of the LLC and doesn't lose ownership of the LLC. And one of the very popular strategies that ends up happening here is that John, in conjunction with Sally, stops making distributions to himself because, why would he make a distribution to himself if that money's just going to go to the creditor? So typically distributions cease, and that puts you in a much better and stronger negotiating position with the creditor, because even though they have $1 million judgment, the creditor isn't actually getting any distributions because those distributions have been cut off. One additional point to keep in mind that I mentioned at the beginning of this video is that John and Sally are business partners. If Sally didn't exist and John owned the LLC as a single member, or if John and Sally were married and they were a husband and wife team, then that whole public policy that we went through at the beginning of the video doesn't really make any sense. It doesn't really apply. John's the only owner of the LLC, and so if the creditor wants to get his 100% ownership, there's no public policy argument against that. And so most states, when it comes to single member LLCs, the charging order protection is not as strong because there's just no reason to give them a charging order as opposed to giving them the actual 100%. So that's really why we always stress to have especially your holding companies, that's why we usually stress that if you have a holding company, you want to make sure it's in a state where not only is the charging order the exclusive remedy available to a creditor, but that remedy also extends to single member LLCs, and there are very few states that have that protection. So if you have an LLC, drop a comment below and I'll let you know whether that's in a very good asset protection state because of the charging order or whether you should consider moving that LLC somewhere else.